Hi, and welcome to this latest immigration law update video. In this video, I wanted to give you an update on deprivation of British citizenship. Over recent years, we've seen a massive increase in the number of deprivation decisions taken by the Home Office. And we've seen an increase in the number of appeals coming before the tribunal. And there's been a change in the approach following the decision of the Supreme Court in the Shamima Begum case. So I want to look today at a new piece of reported case law from the upper tribunal president showing the correct approach to deprivation appeals, and look at the recent Home Office policy guidance and give you some helpful extracts from that policy guidance, which you can use in representations when you're seeking to resist deprivation or drafting appeals skeleton arguments for appeals before the tribunal. If you're interested in my free immigration law resources and immigration law updates, do scan this QR code or click on the link, and I'll put the link below this video. And on that link, there are a number of free PDFs from me. You can get access to various of my webinars and download the PowerPoints from those webinars and much more. So the new case is Chimmy, and that is 2023 UK UT 115. It's dated the 19th of April, and it's a decision of the Upper Tribunal President, Mr. Justice Dove, and Upper Tribunal Judge Blundell. And Chimmy was represented by the excellent Emma Rutherford from my chambers, number 8 chambers. And the link to the Bailey judgment is there, and it's also below this video. So Chimmy sets out the correct approach for tribunals to take in determining deprivation appeals. So it says this: a tribunal determining an appeal against a decision taken by the respondent under section 42 or 43 of the British Nationality Act should consider the following questions. So it's useful when you're doing an appeal skeleton argument to address these questions in turn, because this is how the tribunal are going to approach it. And one of the questions in Chimmy was whether the same approach to appeals should be in 42 appeals, which is conducive to the public good, which Shamima Begum was one of, and 43 appeals, which is the fraud and misrepresentation appeals. And the tribunal determined that the approach should be the same, because questions had been raised following the Supreme Court decision in Shamima Begum, where the Supreme Court said, well, it's not a merits review, it's a public law, a rationality challenge to the condition precedent. Questions had been raised whether the same approach should be taken in a fraud case under 43. Well, the tribunal has held that the same approach should be taken in both. So actually, this case is very useful in the way it sets out the approach and is very clear, which is refreshing. It says this: did the Secretary of State materially err in law when she decided that the condition precedent in section 42 or 43 of the British Nationality Act was satisfied? If so, the appeal falls to be allowed. If not, you move to B. Did the Secretary of State materially err in law when she decided to exercise her discretion to deprive the appellant of British citizenship? If so, the appeal falls to be allowed. If not, you move to C. C, weighing the lawfully determined deprivation decision against the reasonably foreseeable consequences for the appellant, is the decision unlawful under Section 6 of the Human Rights Act 1998? If so, the appeal falls to be allowed on human rights ground. If not, the appeal falls to be dismissed. So the first question is the condition precedent, and the tribunal's looking at, did the Secretary of State err in law? Second question is the question of discretion, and looking again, did the Secretary of State err in law? And then thirdly, the tribunal making its own merits review, assesses human rights. So the first two questions, condition precedent and discretion, it's a question of did the Secretary of State err in law? And notice that phrase they use, materially err in law. It's not limited to sort of a narrow rationality approach, as we'll see, it can encompass all public law errors. Then discretion, then human rights, but human rights is a merits review. Then 2 and 3 look at evidence. So in paragraph 2 of the head note, it says, in considering questions 1A and B, so that's the condition precedent and the discretion, the tribunal must only consider evidence which was before the Secretary of State or which is otherwise relevant to establishing a pleaded error of law in the decision under challenge. So you can have evidence that wasn't before the Secretary of State in relation to questions 1A and B, but it's got to relate to that pleaded error of law. So we need to be targeted in the way we challenge deprivation decisions. And insofar as the case of Boudicca suggests otherwise, it should not be followed. The head note to Boudicca is a bit weird because it doesn't seem to relate to the rest of the decision, but they're clear in relation as to what evidence can be considered in terms of the condition precedent and in terms of discretion. In terms of human rights, look at paragraph 3. In considering question C, the tribunal may consider evidence which was not before the Secretary of State, but in doing so, it must not revisit the conclusions it reached in respect of questions 1A and B. Let me set out a few key paragraphs for you that might be helpful. In this paragraph, they look at the statutory language in terms of paragraph 42, deprivation that is conducive to the public good, and they look at the Lord Reed's judgment in Shamima Begum, and they contrast it with the language in section 43, which is the fraud misrepresentation at section, and they find effectively the language is the same, so the approach should be the same. Look at the final sentence. In short, therefore, there is nothing in either the statutory language or the applicable reasoning to distinguish appeals under section 43 of the 1981 Act from appeals under section 42 of that Act. So therefore, at paragraph 55, they say it follows from our conclusion that we're satisfied when considering an appeal under section 40A1 of the 1981 Act. So that's where you get your right of appeal against a decision made by the respondent exercising the power under section 42 or 43 of the 1981 Act. The task of the tribunal is to scrutinize using established public law criteria whether or not the conclusion that the condition precedent to depriving the appellant of citizenship has been vitiated by an error of law. And they set out here that it's not the task of the tribunal to undertake a merits-based review and a redetermination. And that's consistent with the approach in the head note to Cicely and which relies upon the approach of the Supreme Court in Begum. But what they do, which is very helpful at paragraph 56, is amplify the understanding in terms of the public law error. And they say, we don't think the public law error should be restricted as to whether the respondent has acted in a way that no reasonable decision maker could have acted, or taken into account irrelevant considerations or disregarded matters which should have been taken into account. And that's the language used in paragraph 71 of Begum by Lord Reed. And they say, well, effectively, Lord Reed wasn't there sort of narrowing what is a public law error. And they can consider questions of fairness beyond procedural impropriety. They also refer to errors of fact, and they rely on the E and R case, or a failure in terms of the Tameside duty to undertake sufficient inquiries. So in that extent, what they've done in this case, which is very helpful, is widen the approach in terms of clarifying that it relates to any public law error when considering the condition precedent or the exercise of discretion. At paragraph 60, they clarify the order which should be taken. And they clarify that their approach is condition precedent first, then questions of discretion, before we come to the wider, the broader canvas, as they say, consideration of Article 8. In terms of evidence, then, at paragraph 61, they clarify in terms of evidence, the question which then arises is as to what, if any, material which was not before the respondent at the time the decision was reached could be taken as admissible in respect of this jurisdiction. Again, we're clearly of the view that the evidence to be considered in relation to the exercise of the error of law jurisdiction in respect of the statutory decision, so that's when considering the condition precedent or the discretion, is not limited to that before the respondent at the time when the respondent's determination was made. However, any evidence must be strictly relevant and admissible only because it directly pertains to an error of law which the appellant has specifically pleaded. So we need to be specific in the way we challenge deprivation decisions. So then if we want to rely on evidence that was not before the Secretary of State, we can say, look, this relates to the error of law we say the Secretary of State has made in relation to the condition precedent or to the discretion. Furthermore, the evidence will bear upon the facts and the circumstances pertaining at the time when the decision was reached, and they refer then to the administrative court guidance and De Smith's judicial review. In terms of Article 8, of course, things are wider. So paragraph 72, as can be seen in considering issues arising under Section 6 of the 1998 Act, the exercise is qualitatively different from the public law review of the Secretary of State's decision on the condition precedent and the exercise of her statutory discretion. The question of whether the lawfully determined deprivation decision under Section 42 or 43 would give rise to a violation of the appellant's rights under the ECHR is one for the FTT or the UT to determine for itself, and in respect of which evidence will be admissible which may be different from that which was before the respondent at the time of the making of the decision. And the relevant time there is the date of the appeal decision, and they refer to the upper tribunal at case of Miss Leger from 2022. So that's the correct approach to appeals as currently set out by the upper tribunal. And with all of my videos, do check for updates to case law and policy. And that's where we're going now, to the new Home Office policy guidance, Deprivation of British Citizenship, version 1, which is dated 10th of May 2023. Here's the link, and I'll put it below this video. I've put out some helpful extracts. This is not the whole thing, so do consider the whole guidance. But this is worth citing from when you're making representations where the Secretary of State has indicated they're minded to make a deprivation decision, or you're drafting grounds of appeal. So I'll just quickly summarize this. The first thing in the guidance I want to refer to is it sets out the provisions. So section 42, conducive to the public good and they would not become stateless. Section 43, registration or naturalization obtained by fraud, false representation or concealment of a material fact. And then 46 relates to concealment before 1st of January 1983. Again, the Secretary of State's guidance refers to the relevance of human rights and Article 8 and the balance that the impact deprivation will have against the reasons for depriving. They refer back to the case of Aziz and the need to distinguish between the impact of the decision to deprive, which is being considered, rather than a decision to deport. So remember, in deprivation, we're looking at the Article 8 impact of a decision to deprive. Obviously, questions of deportation and removal and the Article 8 impact of that will come at a later date if deprivation action is taken. I was approached the other day, actually, at a seminar I was doing, and somebody asked me, when would the Secretary of State take decisions on conducive to the public good grounds? And they give some examples. They're non-exhaustive examples, and they refer to the interests of national security, terrorism, hostile state activity, or any other reason, serious organized crime, war crimes, crimes against humanity, and obviously these may overlap. So that's the sort of stuff they're looking to in relation to decisions under Section 42. Use the provision of statelessness in conducive cases, but note Section 40A provides for deprivation of British citizenship on conducive grounds, even if it would render a person stateless, if they've conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country or territory. So that's what was being argued in Shamima Begum, while she can access Bengali citizenship. So we're looking now at fraud stuff effectively. When considering whether the deprivation is appropriate, you must ensure that it is based on sound evidence and not reliant on speculation. So that's worth setting out in your representations. The standard of proof to be applied when determining whether to deprive a person of British citizenship on the grounds of fraud, false representation, or concealment of a material fact is the balance of probabilities. So you've got to be satisfied that it's more likely than not. There's some helpful guidance here on multiple names, and guidance is given. You must take care not to mistake such legitimate instances of name change for an attempt to deploy a fraud, unless it's found that the person has deliberately submitted an application using another name to conceal criminality or adverse immigration history. So factors to consider: whether there was a deliberate intention to deceive. Examples of where a person can be deprived of British citizenship on the grounds of fraud are where they have falsified elements of their personal details to gain citizenship, deliberately withheld relevant information that would otherwise lead them to being refused citizenship, committed a fraud in a previous immigration application that had a direct bearing on their application for citizenship. Must take into account the following factors. So it's worth making representations on this second set of bullet points on the slide. Whether the fraud was material, so materiality, whether there was an intention to deceive, any delay, the case of Lachi is helpful there, the reasonably foreseeable consequences of deprivation, and whether there are any mitigating factors. And there are guidance on each one of these bullet points, and I've set these out. So this is the question of materiality. So would it have made a difference to the decision on citizenship? If the fraud, false representation, or concealment of material fact did not have a direct bearing on the grant of citizenship, it may not be appropriate to pursue deprivation action. And the helpful example they've given is where somebody was granted settlement under a concession where identity and nationality were not qualifying criteria. So despite the fact that they used a false identity at the time, the fraud cannot be said to be material to the grant of settlement. It might therefore not have been material to the grant of citizenship. There's also guidance of when partners should be deprived. I've certainly had cases where the principal has been deprived and then later on they've taken action against a partner, but that mustn't be automatic, the guidance said, and they must look at the partner separately. There's guidance there on what an intention to deceive is, and there must be conscious, premeditated action in order to obtain British citizenship. And examples are given, asking somebody else to take such things as an English language test. An innocent error or genuine admission should not lead to deprivation. Again, something that should be set out in your representations. And then there's reference to adults and children. Again, delay is relevant. Look at it, as I said, the case of Lachi, where there was that, I think, 9-year delay from their initial letter saying we're thinking of depriving you to actually taking action. And then mitigating factors are set out. So are there any mitigating factors set out in your case? Mental or physical impairment that impacted the person's judgment? Are there coercion? But then look at the factors that are unlikely to amount to mitigation, where you've involved a family member or a representative or an interpreter advised you to provide false details. And evidence, if you're going to evidence physical or mental impairment, you're going to need expert medical evidence in relation to that. And then finally, factors which would not usually lead to a decision to deprive. fraud that postdates the grant of citizenship, if the person was a minor on the date to which they applied for citizenship, if the person was a minor on the date on which they inquired, indefinite leave to remain, and the false representation, concealment of material fact or fraud arose at that stage, and leave to remain to the led to the subsequent acquisition of citizenship. So that guidance is there now and should help you, particularly when making representations in relation to the Secretary of State's intention to make a deprivation decision. You've also got the case of Chimmy, which guides you as to the correct approach and the questions to ask in deprivation appeals. I hope that's helpful to you. Thank you very much.